Good evening, everyone. Thank you for joining our webinar today. Before starting, I will provide you a brief introduction of the platform and how you can use the Q&A session. We will be three speakers presenting today, which will follow after with the Q&A session. Please be advised that the webinar is being recorded and the recording will be available afterwards. If you want to access a particular part of the presentation, or if you missed some part, you can always rewatch the recording on the Cloudcast platform. If you want to participate in the Q&A session, you need to push the plus button in the right bottom corner of the window and push the ask question. The questions could relate to individual presentations of our speakers or else to the general topic of the webinar. Without further delay, I will start the introduction of our speakers. Afterward, we will begin the webinar. First of all, I would like to thank our speakers for accepting our invitation and joining the webinar today, providing their knowledge and expertise to us. I will present our speakers in the order they are going to present today. And we'll start with Mr. Avedikian. I believe Mr. Avedikian needs no introduction in Armenian legal community, but as a brief introduction, he is managing partner at GPartners law firm, and before that, he was serving as the general counsel of the Central Bank for Armenia for 12 years. He has more than 2 decades of experience under banking, capital market, and insurance law, as well as financial regulation and public policy. Mr. Avedikian has authored and co-authored more than a dozen of laws that have significantly raised the quality of both financial regulation and private transactions in Armenia's financial markets. Mr. Avedikian's practice areas are corporate, commercial, and financial transactions, corporate restructuring, mergers and acquisitions, business and financial regulation, venture and private equity finance. Mr. Avedikian is also an adjunct professor both at the American University of Armenia and French University of Armenia, and teaches transactional business and financial law. Today, Mr. Avedikian will be presenting regarding the Armenians' COVID-19 measures and what impact those would have on businesses as well as investors and investments made to Armenia. Our second speaker is Mr. Grigoryan. I believe many involved in the arbitration field already know Mr. Grigoryan, since he is one of the pioneers of developing arbitration in Armenia. He has almost 20 years of practice specializing in arbitration and litigation. He is a civil and common law trained lawyer and is uniquely placed to provide strategic legal advice concerning large and complex disputes, often involving a cross-border element. He has advised and represented clients in more than 100 arbitrations under the rules of major arbitral institutions, as well as litigation proceedings across a host of various jurisdictions. Mr. Grigoryan has also published in Law and Practice of International Arbitration in the CIS region, which was edited by Kai Hover. To add to the stated, Mr. Grigoryan has also served as a coach for various arbitration moot teams from Armenia, participating in the William Bismuth Commercial Arbitration and Frankfurt Investment Arbitration moot court competitions. He has also served as my team coach during the internal arbitration competition of Armenia. Today, Mr. Grigoryan will be addressing the standards of protection provided to investors that could be violated by the COVID-19 measures. And our last speaker, but not least, is Mr. Rubins, who will be presenting today regarding the protection standards of states, regarding the protections of states in case of potential investment disputes. Mr. Rubins heads the International Arbitration Practice Group in Paris, as well as the Global CIS Russia Dispute Resolution Practice Group at Freshfields. He is a US and English qualified Russian-speaking lawyer who has represented clients nearly in 100 arbitrations under ICSID, ICC, AAA, SCC, BIAC, LCIA, UNCITRAL, and other rules, including some 30 investment treaty disputes. He specializes in construction and energy disputes, particularly upstream percentage contracts and other auspices of bilateral investment treaties. Mr. Rubins has practiced law in New York, Washington, Houston, and Istanbul, and has also served as an arbitrator in over 40 cases under ICC, LRCI, SCC, ICSID, TIAC, and UNCITRAL rules. Mr. Rubins speaks English, French, and Russian, and has a working knowledge of Spanish and Hebrew. He has published 3 books on investment arbitration and related topics, and also he has over 60 publications in the same field. Today, he will provide his presentation about state defenses. So without further delay, I will give the screen to our first presenter, Mr. Barujan Avedikian. So please, you can start.
Well, thank you so much, Aram, for this generous introduction. And also, I would like to welcome everyone. I was really looking to this webinar. I think it's a great idea to come forward with such an initiative. And thanks to the AUA Legal Clinic or Alternative Dispute Resolution Clinic for this initiative. So it's a challenge for a lawyer to talk about various things in a short period of time, but I know that the webinar has strict rules on timing, so I'll try to be short and respect the time. Let me try to share my screen. I have a presentation. Okay, share screen. So, Aram, I have a question. I'm just pushing my share screen button, and the computer is telling me that there are no more seats left in this event. I don't know what does that mean, but can you see my screen? No?
We can't see you either at this point. I think you might have left the room by accident. You're on mute.
Okay, sorry about it. It's saying for some reason I'm not able to share my screen. Can you hear me now?
Just a second, I will try to solve the issue.
I'm pressing share screen and it's telling me that there are no sheets.
Can you please try again?
Share screen. There are no more seats left in this event. No.
I think if you try now, it will work.
Okay, share screen. All right. Okay, you can see my screen now?
Yes.
Okay, you can see my presentation?
Yes.
All right, wonderful. So as Aram introduced, I'll be speaking about Armenia's measures affecting foreign investors. I have 2 themes and 3 issues to cover today. And the first issue is a general civil code application issue, and the second theme would be more specific. I'll try to talk about the latest developments in the legal field concerning civil asset forfeiture during the COVID-19 times. So under the first theme, I will talk about the termination of liabilities under the Civil Code of Armenia and some constitutionality issues. Let's begin with the Civil Code application of termination of liabilities. So we have the Civil Code Article 433(1) of the Civil Code, which states that the parties can terminate the liabilities if one of the parties cannot fulfill its liabilities towards the other, in case the government has taken, or the state has taken, a decision which makes it impossible to honor or fulfill the liabilities, and the other party, the aggrieved party, is entitled to damages
based on Article 15 and Article 18. That is, this allows for the termination of commitments, liabilities, obligations under a contract when the government has made a decision. And our government has made some decisions lately. Many of you know that for the past almost more than 2 months, Armenia is under the state of emergency, and now we are in the third term of the state of emergency. So if we come to Article 15 of the Civil Code, which talks about mainly the annulment of decisions, it says that the court may annul a governmental or a state decision in case there is a contradiction with law, or it infringes the rights of a certain party. Okay, this is Article 15 under Armenian Civil Code. And then if we go to Article 18, it says that in case the governmental decision is annulled by the court because of the government's or an official's unlawful action or inaction, the aggrieved party is entitled to damages. So this is the regulatory framework that we have concerning termination of liabilities. And as many of you know, right now, since we're focused in Armenia, many companies, many businesses, many investors are in discussion with their counterparts about the termination of liabilities. So in case those liabilities are terminated, the state, because of the governmental decisions or the decisions of its officials, the parties may be entitled to damages from Armenia. And this takes me to the second issue of constitutionality. And since we are under the state of emergency for more than 2 months now, this is a legal decision taken by the government, and which becomes well, after the decision, the parliament has to have a special session where the government presents its proposal, and after that of instituting or prolonging the state of emergency. So now we're in the third term. Now, what I suggest is to take a look into Article 121 of the Constitution, which is the basic source of law for not only for state of emergency but also for the other issues. But this specifically is for the state of emergency. And it says that in the event of an imminent danger posed to the constitutional order, the government shall declare a state of emergency. That is, the Constitution gives the right to declare a state of emergency only if there is an imminent danger posed to the constitutional order. So to understand better what is this issue of imminent danger to constitutional order, we need to take a look into the state emergency law, which is a specific law covering issues and processes and requirements for announcing a state of emergency. And Article 1, for the first article of the said law, it gives some examples of situations that endanger the constitutional order of the country in order for the government to announce a state of emergency. And those would be change or overthrow of constitutional order, attempts to seize authority, military crashes, mass unrest, disorder, national, racial, and religious violent conflicts, terrorism, seizure of special public assets, formation and activities of illegal militia, extraordinary situations. And this is a list. This is a list that the law gives. And now the question is, do pandemics fall under this list? And this is a big question that I would like to pose. I certainly do not have the answer to this, whether the pandemic shall be considered as an extraordinary situation under the state of emergency law that poses an imminent danger to constitutional order or not. This is subject to decision. But why I'm bringing this up? Because in case after the state of emergency is lifted, in case there is a termination of liabilities from one side, the aggrieved party may use these regulations of the Constitution, of the state emergency law, and of the civil code to bring claims against the government, both for the termination of the contract and for damages. Of course, again, this is subject to the discussion and scrutiny whether a pandemic shall be considered as an extraordinary situation. Mind you that during this time, the government has already extended the state of emergency for the second time. So, as I said previously, this is our third term in the state of emergency. And during this time, the government never changed the legislation to include the pandemic in this extraordinary situation, which gives another room for discussion later on. And it will be interesting to see how this field develops and whether we will have any judgments in the field or not. So this was the first theme. I know we can speak about this for some time, but because of time limitations, I'll stop here and maybe later on take questions. And I'll go to the second theme, which is the brand new forfeiture of illicit assets law that was signed into law May 11th. And it certainly is not COVID-19 related, but it was adopted during the COVID-19 period. And many commentators and legal scholars raised issues whether this law had to be adopted during the time of state emergency, during time of COVID-19 crisis, where the country is in certain limitations for raising dissent to parliamentary actions. Anyhow, the law was adopted in the end of April. It was signed by the president into law in May 11th. Again, a whole webinar or seminar can be dedicated to this issue. So I'll just put out there the question and I'll leave it at that. And again, if we need to discuss it during the Q&A session, I'll be happy to do it. First, let's see what's the definition. According to the definition of the FIA law, assets that have been acquired or transferred since 1991 and the acquisition of which cannot be substantiated with lawful income may be considered as illicit assets. And if the assets are considered as illicit by the prosecutor's team, by the prosecutor's office, then those can be forfeited by a court order in a civil litigation. Now, I'll just pinpoint some issues over there, again, without going deep into the subject as we don't, as we are limited. The first issue that I would like to bring up is the shift of burden of proof, which is the shift of burden of proof, that is the good faith test. That is, the acquirer should prove that it didn't reasonably know that those assets are illicit. So if you're a foreign investor and you've acquired some assets in the country, and it happens that the prosecutor's office is going after the seller of those assets, you still have to be involved in the process somehow and try to prove that you didn't know that the acquirer had acquired the assets previously. And again, they can go back to 1991 with illicit process. So there is no objective tests available in the law. There is a lot of uncertainty. There is a wide net issue. So the law does not clearly target certain unlawful groups or illicit activities. Though when adopting, the parliament said that, or the ruling fraction in the parliament said that this law is targeted to corrupt officials, but it has a wide net and it covers larger number of transactions, types of transactions, and of course many fractions and even non-parliamentary political parties have already applied to the ombudsman to question the constitutionality of this law, which creates further uncertainties in regard to foreign investments. So I know that in my presentation there might be many questions or comments, but I'll stop here to give my colleagues some time to present their ideas as well. Thank you.
Thank you, Mr. Avedikian, for your interesting, insightful presentation. I will invite to the screen Mr. Sarkis Grigoryan to continue with our webinar. And in the meantime, if you have any questions in relation to Mr. Avedikian's presentation, please feel free to put those in the Ask Question window.
Is Sarkis still there?
Yes, he has just joined. Mr. Grigoryan, you're on mute. Just let me unmute. Oh, okay. So please, if you have any presentation to share, you can do that now. And afterwards, we can start.
Can I start?
Yes, sure.
Good. Aram?
Yes, we can see the presentation. You can start presenting.
Thank you very much. Aram Can, again, thank you very much for this introduction and for this event. It's really a pleasure to participate in this event during the pandemic crisis. This novel crisis, coronavirus, is changing the world order. Since the middle of March 2020, we are in state of emergency here in Armenia. And as presented by Varujan Avedikian, it entitled the government to perform actions or impose policies that would normally not be permitted to undertake by government. And it's true that government of Armenia has adopted unprecedented economic measures to tackle the COVID pandemic crisis and keep our economy afloat. Currently, the state measures are affecting investments in many ways, both positive and negative. There have been various interventions by the government. Here, I would prefer not to give any legal qualifications about those interventions or policies. However, let me say that foreign investments are likely to be particularly affected by these governmental measures and restrictions. While the standards of protection provided to foreign investors under investment treaties have been shaped by decades of international arbitral practice, the unprecedented nature of COVID and the state of emergency it has provoked are likely to raise novel issues in investment disputes. So, a range of legal instruments have developed aiming to dispel investors' concerns as to the protection of their legal rights in the event of interference by governments. The most important of these instruments are the modern network of investment protection treaties and the contractual stabilization provisions. In recent years, there has been a trend towards the government of Armenia asserting its sovereignty more forcefully against foreign investors' contractual rights. This has resulted in explosion of investment disputes. Thus, generally speaking, there are four instruments we need to consider to protect investors in this country. Firstly, it is the Foreign Investment Act adopted in 1994. Though it is an old legal instrument, it ensures certain treatment for investors. For example, to pay fair, prompt, and adequate compensation in the case of expropriation, or accord foreign investors due process and not deny justice. Secondly, an investor may also enter into investment contract with a government. Examples of such contracts in the extractive industries are concession agreements under which investors receive certain protection so they can invest in the exploitation of natural resources. Finally, one of the most striking features of the explosion in FDIs has been the increase in investment treaties entered into by host states. The investment treaties can take the form of bilateral investment treaties between two states or multilateral investment treaties. Let me give you some figures. Armenia has more than 45 treaties. The first one was signed with China in 1992, and the latest investment treaty was signed with the Republic of Korea in 2019. Legal instruments, the specific substantive protections granted to foreign investments under Armenia's bilateral investment treaties will depend on the exact language of the treaty. In the context of the COVID emergency, the protections that investors are more likely to invoke include fair and equitable treatment, the guarantee of protections equal to those given to national investors, and protection from unlawful expropriation. Moreover, we shall say that Armenia must also accord foreign investors due process and not deny justice, as well as honor commitments in commercial contracts. Importantly, most investment treaties also provide for dispute resolution by arbitral tribunals established under the International Center for the Settlement of Investment Disputes or other arbitration rules, let's say, for example, UNCITRAL. To bring a claim against the government, aggrieved investor must comply with procedural requirements set out in the relevant treaty, which may require, for example, advance notice and observance of cooling off periods before a claim can be filed. Yeah, by the way, we need to say that the most arbitral institutions, including the ICSID, appear to quickly adapting to the novel challenges posed by the COVID and actively encourage electronic filings and online hearings to ensure continued operation. Yeah, standards of protection. Before discussing certain standards of protection, let me emphasize that international protection is restricted to foreign investors and their investments in Armenia. It involved the use of capital, technical and managerial skills, patents, and other intellectual property, as well as a variety of other assets. Activities that have been accepted as investment include mining operations, the construction and operation of hotels, banking infrastructure projects, shareholding, as well as financial instruments, including, for example, loans. Yeah. Fair equitable standard is designed as a rule of international law. However, it's not available in our domestic legislation. This standard may be violated even if the foreign investor receives the same treatment as local investors. Certain principles have evolved which may be described as transparency, consistency, stability, and protection of investors' legitimate expectation, as well as, we need to say, compliance with the contractual obligations and freedom from unlawful pressure. These categories by no means exhaust the possibilities of the fair and equitable treatment standard. Another standard is full protection and security. Those clauses guaranteeing the investor's full protection and security are included in most bilateral investment treaties. However, it's not again enshrined in our legislation. The treaties required not only abstention by Armenia from physically damaging foreign investment, but also positive measures to protect foreign investment, in particular against harm caused by private actors. Armenia's responsibility also extends to actions committed by its organs, for example, ministries, let's say the Ministry of Environment, or municipalities, the municipality of Yerevan, as examples. Of course, it's beyond doubt that this standard is also applicable on protection to direct attacks on the investor's property by state instrumentalities. Yeah, there is also authority indicating that principle requires legal protection for investor, for example, legal security and certainty. In well-known case, SME and Czech Republic, the standards was violated by change of the legal framework that rendered the investor vulnerable to negative action by private persons. This standard does not provide an absolute protection against physical or legal infringement. In terms of the law of state responsibility, the host state is not placed under a strict liability to prevent such violations. Rather, it is generally accepted that the host state will have to exercise due diligence and will have to take such measures protecting the foreign investment as a reasonable under the circumstances. National treatment or MFN treatment, those principles are contained in virtually every bilateral investment treaty signed by Armenia. And it is also the case in the Foreign Investment Act of 1994. Thus, the national treatment provides that foreign investor and its investment are to be treated no less favorably than Armenian nationals. And better treatment of the foreign investor remains possible and will even be required if the international standards are higher than the ones applying to nationals. As regards the MFN, the purpose of it in investment treaties is to ensure that the relevant parties treat each other in a manner at least as favorable as they treat third parties. The standard is relative and depends on the benefits enjoyed by the third state and the nationals in Armenia. Expropriation. Protection against unlawful expropriation is cornerstone of international investment law. Provisions addressing direct and indirect expropriation are contained in virtually all modern bilateral investment treaties, including signed by the Republic of Armenia. As you may know, expropriation is not illegal under international law and Armenian legislation. Article 8 of the Foreign Investments Act regulates those legal issues. That article is also applicable under a state of emergency. It has always been beyond doubt that a state has a power and the right to expropriate the property of the nationals and of foreigners in principle. The same right, as you may know, is also available in Protocol 1 of the European Convention of Human Rights, Article 1 of Protocol 1. But a legal expropriation of foreign-owned property is subject to certain conditions. These conditions are commonly referred as a public interest, absence of discrimination, due process of law, and compensation that is prompt, adequate, and effective. Yeah, we need to emphasize that tribunals tend to recognize expropriations only where the deprivation is total or substantial. Even a grave interference will not amount to an expropriation if it leaves a measure of control in the hands of the investor. Tribunals give increasing weight to the police powers of host states. Under this doctrine, legitimate regulations affecting foreign investors will not amount to expropriation. I think Noah is going to discuss those legal issues in detail. Let me conclude. For Armenia to avoid liability for measures adopted in response to the COVID pandemic, it's crucial to be very transparent about the scope and the purpose of its measures, to observe applicable domestic laws and fundamental principles of due process, such as non-retroactivity, as well as to ensure proportionality, and that measures do not favor or discriminate against investors based on their nationality. Thank you very much.
Thank you, Mr. Grigoryan, for your very insightful presentation. Mr. Rubins, now we'll give the floor to you. As far as I'm aware, you don't have a presentation, yes?
That's right. I won't be using slides today. I hope I can keep everyone's attention just with my words. Everyone, thank you so much, the organizers, for having me today. It's very exciting for me to be virtually with you in Yerevan. I was saying to my co-presenters, yesterday I was in Kiev, and today I have the pleasure to be in Yerevan. In normal times, I wouldn't be able to do that. And so this is the positive side of the strange situation we're all living in today. And it is a strange situation, and it's giving rise to government action on a scope and a scale that we have in our adult lifetimes we've never seen. And that is going to mean that people, businesses, investors will be thinking about what, if anything, they can do to be compensated for the harm that they suffer as a result of the state actions in response to COVID-19. And the answer, let's start from the beginning, the answer may be nothing. At least in the international plane, which is what we are talking about today, the answer may be nothing. And the important thing is to think through these issues and to consider, based on the instruments, the legal instruments we have, and some prior decisions of tribunals, what the likely result is going to be. Now, what are we talking about in terms of the kinds of measures that might get investors thinking about litigation, about arbitration against the state of the sort that Sargis was just talking about? Well, there's a range of very invasive measures that states have taken, largely as an attempt to control the health effects of the virus. Just as an example, measures that might lead to a claim of expropriation include the exercise of state powers to seize land or other property, as has been done in China. if the seizure isn't accompanied by prompt and effective compensation, the takeover of factories and laboratories that might be used to produce vaccine components, which has been contemplated in places like Spain and Turkey, the requisitioning of hotels and medical equipment, which has happened in Italy without clarity on how the affected businesses will be compensated, the exercise of powers to require companies to produce certain goods. Well, that's been done in the United States with respect to General Motors. So you can see there's a wide range of actions that have already been taken, not just in Armenia, but all around the world, that affect businesses in a way that they are not accustomed to and that they perhaps did not expect. And given the wide protections that are provided by investment protection treaties, as Sargis just explained, the question is, well, why not? Isn't this an expropriation? Isn't this an unfair and inequitable treatment? Well, it's not quite so simple. And no doubt if there are claims, whether it be against Armenia or against other countries around the world for the steps that they have taken to control COVID-19, it's not at all clear how successful those will be, because there are a range of legal defenses that will no doubt be available to those states to defend against investment treaty claims in this very, very odd context. Now, I should say we don't know what the result will be, so I'm just going to talk about the most likely defenses. Many of these defenses have been used by states, both successfully and unsuccessfully in prior cases. The most prominent emergencies or extreme situations that led to investment treaty claims, the two most important ones were, number one, the local crisis in Argentina at the beginning of the 2000s, which led to a complete meltdown of the economy there. And in that situation, there were riots in the streets in Buenos Aires and people died. And the response of the state was to implement a range of very invasive measures, economic measures, that transferred value from foreign investors to local consumers. And the Argentine government's defense to the 30 or so cases that came after were not, let's say, particularly successful. And the second was the 2008 financial crisis, which also gave rise to claims against Greece, against Cyprus, and certainly against Spain in relation to renewable energy. Well, what will those defenses be in the case of the COVID response measures? Well, first of all, states will no doubt say that in a situation like this, those standards only apply beyond a certain reasonable discretion of the state to defend its people. And that is what's often referred to as the fundamental right to regulate, particularly in relation to public order and to public health. And the most prominent example in this area is a very high-profile case called Philip Morris against Uruguay, which was a case regarding plain packaging of cigarettes. Doesn't seem like it has much to do with COVID-19, but actually it does, because Uruguay was sued for forcing Philip Morris to eliminate all advertising off of its packaging, and Uruguay said it had to do that to control a smoking problem, which was a massive impact on the health of its people. And Philip Morris said, "You have expropriated our intellectual property rights." Now, the result of that was a loss for Philip Morris and a victory for Uruguay, because the majority of the tribunal said that regulation in the interest of the public health is within the discretion of the state. It is not unfair unless the measures were unreasonable and not properly connected to the public health goal that it is said that they are to defend. So in that case, the police powers doctrine protected Uruguay from liability. So in a case of COVID-19, you can see what the argument will be. It will be, okay, if we shut you down for 3 months and killed your business, we had to do that to protect your workers and all the other workers. We couldn't allow you to operate and have other businesses operating shut down, excuse me. So that's just a general interpretation of the protection standards. But there's also treaty-specific exceptions to liability in many investment treaties, which will provide a forceful defense for states like Armenia if they are sued in relation to COVID-19. And I just want to give you one example from the treaty between Armenia and Japan, which is a very recent treaty from, I think, year before last, from 2018. And in Article 16, there's a provision called General and Security Exceptions. And it effectively says there will be no liability for measures that are taken as necessary to protect human, animal, or plant life or health, or necessary to protect public morals or maintain public order. So you can see in a COVID-19 situation, an epidemic situation, that will be a pretty obvious defense for the state. And the claimant will have to say, what you did to me was not necessary in order to achieve that goal. And maybe they'll be successful and maybe they won't. That will depend, as Sargis said at the end of his presentation, on how the measures were implemented. Were they discriminatory? Were they arbitrary? Were they just a cover for taking value from private investors, or were they bona fide measures to protect the public interest? That will be the fundamental question. So that's treaty-specific issues, but there's more, because there's a further layer of public international law that potentially will kick in to annul liability of the state where otherwise there would be liability of the state. And there are basically three international law doctrines which could be used by states to defend against a COVID-19 claim. The first is force majeure, which is according to Article 23 of the International Law Commission's articles on state responsibility, says if the state is unable to control the situation, typical force majeure, it cannot be liable for the result. And there, of course, the question will be, was the state able to control the situation or was it not? The second is particularly interesting because we've never really seen it invoked in investor state arbitration, but we might see it here, and that's distress. The defense of distress is found in Article 24 of the International Law Commission's draft articles, and it's basically saying that there will be no violation of law if the author of the act in question has no other reasonable way to save lives. Interesting. Almost never seen in investment law, but here the state will say, we were in distress, people would have died. And that's enough to say that what we did is not a breach of law. Now, again, the question will be, was what you did necessary to avoid people dying? That will be the question. And finally will be the defense of necessity. And the defense of necessity, which is Article 25 of the articles on state responsibility, is one that was invoked many times by Argentina in saying, we had no choice. It was necessity because we faced an imminent peril. Those are the words that are used by the International Law Commission. And the tribunals again and again said to Argentina, no, you were not in imminent peril, even though people were dying in the streets. Why? Because it basically has to be a threat that the state will cease to exist. Now, is this epidemic that kind of threat, existential threat to the state? That will be the question. So there will be arguments about the meaning of what is fair in terms of the state's right to regulate. There will be an invocation of all of the treaty codified exceptions to liability found in many, but not all, investment protection treaties of Armenia and other states. And there will be, no doubt, an invocation of these three customary law defenses to liability should there be claims against Armenia in relation to measures it has taken in relation to COVID-19. Those are my comments, and I thank you very much for your attention.
Thank you very much for your presentation and for pointing out these important aspects of protection the states could use. Now we will pass on to our Q&A section and try to answer the questions our attendees have asked. So let's start from the first question, which is directed to Mr. Avedikian. The question, I will read it out. Thank you for interesting presentation. My question will be on the new law on illicit enrichment. I've seen your interview on the issue. I wonder if any action is planned, organized by lawyers and or interested stakeholders to take this law to courts. Do you think there should be a case, or it can be submitted for constitutional review without waiting for a case?
Okay. You can hear me, right? My mic is not on mute, right?
Yes, yes.
So thank you, Adelaida. Thank you for the question. We have a first mover, and the first mover is one of the political parties that is not a parliamentarian party, not introduced in the parliament. I know, and they made an announcement that they have applied to the ombudsman, because the ombudsman has the power to apply to the constitutional court and argue the constitutionality of some of the arguments of the law. We haven't heard back from the ombudsman yet if he's going to make an application or not. If not, then the other option would be to use a specific case, if that happens in due time, to go to the constitutional court. And I know that some lawyers have been thinking about this for some time. But let's wait and see what the ombudsman will decide.
Okay, thank you for the answer. Our next question is directed to Mr. Rubins. I will read it out again. Thank you, Mr. Rubins, and all the speakers for these very insightful thoughts. With respect to the exception in the Armenia-Japan BIT for measures necessary for protecting life, what is the state's burden in proving that the measure was necessary and not simply sufficient?
Yeah, that's an excellent question. There's no complete answer. The basic answer is the invocation of that provision should be an affirmative defense. If it's an affirmative defense, then the state bears the burden to the balance of probabilities. In other words, it must prove 51% that what it did was necessary. All right. Now, there's an argument that it's not an affirmative defense, that it's actually part of the claim, because it says in the provision, it says no measure will be in violation of this treaty if it is one of these things, right? And so arguably, and I'm sure the state will argue this, the burden is on the claimant to show 51% that it was not necessary. So that will no doubt be debated. That's only with respect to the treaty-based provisions, right? Now, remember, there's, for example, the defense of necessity, which is a bit different and much stricter, I think, than the treaty-based provision that we looked at. Because the public international law rule is there can be no other way. It's not just that it was necessary in the sense that there was a direct causal relationship, but it must be that there was no other way to achieve the same result, right? That's the defense of necessity. But the defense under the treaty, I think the most obvious approach is the burden is on the state. It's not a heavy burden, it's a normal burden. And I do think that tribunals will look at that rather flexibly in practice. I think they will say, well, look, submit expert evidence showing that it was a rational way to achieve what you needed to achieve to save people's lives or to protect the public health. And then it's for the claimants to carry the burden and disprove that with its own evidence. So I think it'll start with the state bearing the burden and then shift to the claimant.
Thank you for your answer. Our next question, I believe, is directed to No, it's not stated, but I will read out the question and you can pick up. What are the measures that might potentially result in investment arbitration claims? Any measures that states should avoid at this stage?
So maybe Sarkis, maybe I'll take it just a real quick answer.
Yeah, can you repeat, Aram, please?
Yes, for sure. What are the measures that might potentially result in investment arbitration claims? Any measures that the state should avoid?
So I'll just start with that, and then Sarkis will no doubt have his views on it. I think the most likely claims are not going to be lockdown claims. They're not going to be claims about what was done to address the actual epidemic. It will be claims relating to recovery efforts. It will be claims related to the financial incentives that are given to some, but not to others, in most countries around the world to achieve economic recovery. That's like the Argentine situation, right? Where Argentina lost so many cases. So there, the question will be, what are the benefits that were given? Was it discriminatory? Was there a rational connection between the disadvantage to those who do not receive it, right? Because if they're not receiving it and their competitors are receiving it, that seems unfair, right? And you can already see, for example, in the United States, the Trump administration talking about Buy American type thing, measures to say in this recovery, we're going to make sure that all of the assistance and, for example, state contracts only go to American companies and American-owned companies. And that, we'll see, right? That kind of thing, discriminatory, arbitrary, that's the place I think where you're going to see claims.
Okay, thank you.
Yeah, I agree with Noah. And let me also argue about another standard, which is related to financial incentives or corporate restructurings. It's about the freedom of transfer. And as you know, the primary purpose of transfer provision is to determine a host country's obligation to permit the payment, conversion, or repatriation of the funds that relate to foreign investment. The key issues that arise in a design of a transfer provision can be divided into two categories, and I think the Central Bank of Armenia or the Ministry of Finance must be careful on those issues. The first category relates to the scope of the general obligation undertaken by Armenia. This category includes issues relating to the types of transfer that are covered by the transfer provision in our bilateral investment treaties, and the nature of the obligation that applies to these transfers. And the second category relates to the principal exceptions and qualifications to this general obligation, the most important of which relate to derogation for economic reason.
Thank you very much. Since these were all the questions, I will add several questions which I have to Mr. Rubins. I would like to ask a question in relation to state defenses, but not necessarily in the arbitration proceedings. Is it possible that states could take any action not to end up in the arbitration proceedings at the first stage? So let's say it be a collective agreement or withdrawal of consent. Do you think that kind of action by the state is possible?
Withdrawal of consent to arbitration now to avoid claims later?
And also in stating some kind of a collectively stating that they are not going to consent to investment arbitration claims.
So the state doesn't really have much of a choice, right? So there are these treaties, they've been signed, they've been ratified, and for Armenia, and each of these treaties contains the state's basically irrevocable consent to arbitration. The only way to revoke that consent is to go back to the counterparty, and I use the Japan BIT. So go to Japan Ministry of Foreign Affairs and say, look, we want to terminate this treaty. That's not something that Armenia does every day. It's something that has a serious negative impact on its international reputation and also on foreign investment flows. So I doubt very much that Armenia will want to do that. There really is nothing else that Armenia can do about its consent to arbitrate, and saying I'm not going to participate. Well, the proceeding will go on without the state if it doesn't show up. So that's not a great strategy for the state to take. And I think the better approach is, before taking measures, to consult and coordinate with the foreign investment community and the investment community in general, the local and international investors, to make sure that all the stakeholders are on board. That's the way you avoid investment treaty claims, is by making sure that everyone is on board and understands the need. To be frank, I think if there's engagement between the state and stakeholders, business people around the world are sacrificing a lot for the world community. I don't think they're in the mode of, this is all about me and my profits. That's bad business today. So I think it is possible for Armenia and other states to avoid investment claims. It's by drawing upon the massive goodwill that there is in the business community, by just engaging and talking and negotiating before, invasive measures are taken.
Okay, thank you all very much. I will encourage our attendees to put any more questions, or if not, okay, so we've got another question. So the question, I believe it is directed to Mr. Grigoryan. I'll read it out. What about if the investor has a contract with the government? Whether it will make any difference?
Yeah, it's good question, and we are facing this situation now in Armenia with the investor from the European Union. Armenia's bilateral investment treaties contain so-called an umbrella clause, which is a provision by which Armenia agrees to comply with all of its obligations owed to foreign investors. An umbrella clause can be highly beneficial to any investors, as it may allow the investor to argue that issues ordinarily governed by domestic law, for example, breach by the state of its contractual obligations, can also be characterized as a breach of investment treaty obligation based on the umbrella clause. Therefore, the investor may be able to alleviate of its disputes with the state to the international forum under the protective umbrella of that particular bilateral investment treaty. Thank you.
Okay, thank you very much. I believe this was the last question, and I believe we made it into the specified amount of time which we have decided. With this note, I would like to end the webinar and thank again our presenters for very insightful presentations and for their knowledge and expertise they shared with us. Thank you very much again, and please follow our clinic announcements. We are planning to make more webinar sessions, and you can register to participate in the future sessions as well. Thank you very much.
Thank you.